just the things that you're pointing out are just so real. And to know that currently, as we speak, there's people being held in solitary even after the calls to action just to stop it completely. Michael, is there, after hearing Professor Morgan, is there anything that you'd like to add to that, or what comes up for you?
Yeah, thank you. I think that's really important. Everything that the professor said was right on point, especially like, this was something that I wanted to talk about today too, is how the PIC creates new disabilities, right? And so that brought to mind a person, from my personal lived experience of being inside solitary. I did not know that I had certain disabilities. I didn't even know about the that prisoners had, let alone constitutional rights, but then disability rights under the ADA, right? Until I went to the law library. But unfortunately, for folks that may not be able to see or even hear, or as Amelia had mentioned, um, the way that solitary confinement is designed to silence people. I mean, in the beginning they used it against political prisoners like George Jackson because they didn't want them to have the ability to communicate and organize within prison and then organize against them, right? So it is a form, especially if you look at Pelican Bay. People are actually written up disciplinary write-ups for talking to another prisoner, right? Because then they could use that. Oh, it's a form of gang association by telling another prisoner good morning. I mean, the Madrid versus Gomez case is something that I really encourage everybody out there who wants a real. It's almost like it's kind of sad sometimes, and it's very traumatic because it's almost like reading a book, right? With all these horrific cases of people being tortured inside, and of how it's built, right? And not only of that, how people have been disciplined and even kept inside longer for just simply telling another prisoner good morning, or assisting them with their legal work, or telling a prisoner hello, or talking to them in the law library, right? Because they don't allow any talking. If you're caught talking in the law library, your privileges are revoked for 30 days, and it can go on and on. So it is difficult for a prisoner who, on one hand, is unable to access even such simple things as a form to ask for a reasonable accommodation, right? Because then again, when you're in solitary confinement, it's not like the general population where you could walk over to the prison law library and ask a clerk or somebody to help you out and give you one. Here, you're dependent on the same guards that are probably already torturing you, or being, or humiliating, or what have you, or are just in fact desensitized, right? Because the honest thing about it, and I don't advocate reforming and building, solitary confinement to accommodate prisoners with disabilities, but the fact that these prisons are not, and these solitary confinement units are not built to accommodate physical, nor even mental, or any other type of educational disabilities or what have you, and they do not have any types of programs put in place. So the fact that a prisoner has to rely on a guard to get access to a form in order to file it, and not only that, after he files it, he has to give it to this officer who might throw it away, right? Especially if it's a grievance against him. So I also remember a perfect example of my neighbor who happened to be blind, right? He was a blind man. He happened to be from the same neighborhood where I grew up, and my family are from. And so and in fact, I knew him. I was on a mainline, a general population prison with him prior to his disability. So when we also talk about state created disabilities, right? And I know I don't want to go too far out, but I know Miss Morgan also talked about the violence within prisons, right? So just to wrap it up real quick, this gentleman was a product of state created violence. They put him in a cell with a person that they knew he shouldn't be with, and long story short, he lost his vision. He was stabbed in the eye, and he lost his eyesight, right? And so they even still charged him though for the fight as being a participant in mutual combat. because he wouldn't tell on the opposing person that, oh, he attacked me or what have you. And when people don't tell, they just say, okay, you both are going to be written up for assault, mutual combat. And he was giving solitary time for that. But while he was my neighbor, I saw how the prison guards would treat him. They would literally slide his mail under his door, right? And they know that he's blind. They even make him wear a vest and all this so that they do know he's blind. And then he would tell him like, hey, you know, can you read this to me? Because I'm blind. You're sliding on my mail under my door. And if I try to ask my neighbor, because he's validated as a prison gang associate, I'm gonna be validated too. If we get caught passing things under the door or talking, etc. And they refuse to help him. They refuse to read. They're like, you know what? That's you figure it out. And part of that problem of the desensitization, and also the fact that a lot of guards have this mentality when they're taught, and they even teach this to. I have friends that were working as nurses or educators within the prison, and the guards tell them, "Hey, don't believe these guys. Anything these guys say, they're going to try to manipulate you. They're lying. They're faking. Even about disabilities, they think people are faking, right?" Or they look at a person that's in solitary. Oh well, you committed a fraction. It's almost like you say it's a prison within the prison, right? So in the prison, you committed a violation of a rule, and therefore, you deserve what you get, or you did this, or you deserve what you get. You don't got nothing coming, right? And I think that's a perfect example of how it can exasperate or lead to further deterioration when you're not getting that medical assistance or that reasonable combination to help you. And imagine the effects that it does on you psychologically when you're getting letters from your parents, from your girlfriend, or what have you, your kids, and you can't even read it, you can't even respond back, they can't even see you because in solitary it limits visitation, etc.
Hmm. Hmm. Yeah, I have so much to say. I mean, Michael, like everything that you're saying just is so important. And I just, want to emphasize a few things and just echo because you captured it better than I could. Like the PIC creates new disabilities, right? They're unaccommodated in many cases. And the violence, the harsh conditions of imprisonment degrade bodies and minds. And so that has to be foundational. But as you said, we have rights, right, under the Americans with Disabilities Act, under the Constitution. But those rights are only as effective as how they are enforced. And when I would get letters from people saying, I can't even access the accommodation process, right, let alone a grievance process to get the services that I need, to get the accommodations that I need, whether it's assistive devices, assistance with opening mail, reading mail, understanding, let's say, the inmate, as they call it, inmate handbook. Those services are not provided, and so that builds, in many cases, reliance on others within the facility, and that can create vulnerabilities. As you said, I wanted to touch on a couple other things, like the malingering point. Very often, when I would share the report with staff in some of the facilities, the first thing would say was, they're faking it. How do you know it's real? And it would just get to me because in many ways, like you could see that this culture of not believing incarcerated people when they share information about their bodies just pervaded prison culture. And that aligned in so many ways with what solitary confinement is in prisons. It's a management tool, right? It is there to manage, as you said, Michael, dissent. It's there to quell dissent, to control. When we think about the use of solitary confinement to respond to individuals with psychiatric disabilities, the response is not mental health treatment. We know, I think, we can't truly provide anything like mental health treatment, but in the kind of barest sense that it is provided, it's cell side visits, not consonant with professional norms that we would see out here in the quote unquote free world, and that contributes then to the psychological deterioration that people see. And so then here comes solitary again, right? To segregate, to detain people, to manage them in the very sterile and violent spaces of the quote unquote strip cells, right? Like, think about it. We are responding violently to individuals in crisis in so many ways. produced by the harsh, violent conditions of the very prison. And so when I think about the Madrid case, Michael's absolutely right. That is an important case for advocates to read. I think it's an opinion by Judge Thelton Henderson. And one of the quotes that I recall is something to the effect of like putting an individual with psych disabilities in solitary is like putting someone with asthma in a room with no air to breathe. It's that kind of thing, and I think in so many ways, you know, we fail to at least keep front of mind that there are purposes and functions of these practices, right? In the sterile formulation of a practice, solitary confinement has a function in prison, and that's why it's so hard to reform it, right? And why we have for many years called for abolition, whether I was at the Stop Solitary campaign at the ACLU National Prison Project or the Abolitionist Law Center in Pittsburgh and now Philadelphia, or here now as a scholar. We must abolish it because abolishing it, one, ends the suffering and ends this form of torture, but reckons with the role that it plays in holding together these prison systems, right? And the violence rather that they produce.
Thank you both so much. I mean, this is just, I mean, it's very real, and I mean, maybe in the future that'd be another conversation, right, that we can have around the Madrid versus Gomez a case, and really unpacking that so that advocates really understand the work that has come before right now, right, because this has been a long history of, as Michael has shared with me, of many court filings, right? As your work states, like we're not talking, this is not revolutionary. We haven't just discovered this. These things have gone on. These practices have gone on. Michael, given your participation in the hunger strikes at Pelican Bay to protest solitary confinement, and your experience litigating cases from solitary and helping others who experience various injustices, we'd love to hear your thoughts about strategies to address the harms of solitary and other abusive practices. I know that you touched on grievances a little bit. Will you share with us a little more?
Yeah, definitely. Can y'all hear me?
Mm-hmm.
Sorry. I think also one of the problems with being a person with disabilities in solitary confinement is the racial divide that has been created by the state, right? California is unique in, like, unlike other states like New York, Texas, where they integrate prisoners racially. In California, they segregate prisoners by race, but not only by race, but also by geographical location, right? And factions. And so this has caused, different communities to form, but also a lot of animosity and strife between those groups, right? Which has also become racist at times. As we've seen in California, black and brown have been, killing each other, going at it for so long. I mean, you look at YouTube, you just put, Pelican Bay riot, 1999 or 2000, right? It was one of the largest prison riots in the United States, with over 200 African Americans being reported as being on the yard and involved with over, I think, 150 quote unquote Hispanics, and I think 10 quote unquote white prisoners, right, who joined in. And you can see on the video a personal friend of mine, Sharky, rest in peace, who was shot and killed as he looked up at the guard tower, right? So this separation and divide and conquer strategy has been used to control the prison, and to then even control prisoners who may rise to some type of power within there and have some type of pull, or able to bring people together. Those are the people that they send to solitary confinement, right? And so I would like to say that years or decades upon decades of division, racial division, has caused even folks like myself included at certain times, like, I'll be in solitary confinement with another individual, and whether he's black or he might even be brown, but he's from up north, or he might be Asian or what have you. And at that time, we may be warring, going at it for various whatever. And most of the reasons are really dumb. It's about pride and respect and all that machismo stuff. So when you have that added in the box in this little small container, and you put some fuel on it, it's going to explode, right? And this is also caused by the way the prisons are designed on the general populations, where they'll have only two benches, but they have all these different races. Right now, people are fighting over benches. I'm sure, Vanessa, you can attest to that type of stuff, right? People claiming territory, because it is in prison very territorial, right? But with that comes, the animosity, the division. And then when we're inside, part of those politics, require me, if I want to survive and not be have my group or peers mad at me, I can't help a black person, or I couldn't help a brown person from up north, right? Because of those politics, right? And that division. So that was even created worse, because what if a man is there by himself and he doesn't have any of his peers and everybody is his enemies? Nobody's gonna help that individual, right? And that's one thing that we depend on is community, right? A community inside as well as community outside, because we do have communities inside. Thanks to the war on drugs and the war on gangs, prisons are filled mostly with black and brown bodies from our same communities, right? But and so I think when we're talking about strategies, I think we knew, because the prisoner hunger strikes of the 2000 or 2011, 12, and forward, within the Ashner case, was not the first hunger strike, right? It was not the first movement to end, or rather, at the time, it was more of a reform, right? To reform solitary confinement. And that's the Stephen Castillo case, which a lot of people tend to forget. And he organized a prisoner hunger strike early on, prior to this, right? And even filed a case that turned into a settlement agreement, right? Which was aimed primarily at the time of organizing prisoners, and even bringing light to a problem that exists within prisons that is not talked about. Even though here in Los Angeles, we're barely talking about sheriff gangs, right? But folks like myself, who were raised in the 80s and 90s in the war on the drugs, we know that these gangs existed, right? Long time ago. But there's also the existence of prison guard gangs, correctional officers forming gangs and acting like, like they're invincible, right? And so that brought light to what they were calling the Green Wall, right? There was a Senator Gloria Romero was working with Stephen Castillo and others, and bringing light to this issue of these corrupt prison guards who are also setting up people, right? Um, to fight, to kill each other, to bring in contraband, to make money off of contraband, etc. Right? And so I think keeping all that animosity and division in mind, one of the key strategies was, and it's the main ingredient, was solidarity amongst all prisoners to end all hostilities and divisions, right? And come together in unity. And I think, I would like to quote Emiliano Zapata for his famous quote where he says, as individual fingers, we could easily be broken, right? But together we make a mighty fist. And so that was the key component in strategy in organizing a movement like this. It took all of us to come together, to put our differences, racial, gang differences, or what have you. I don't even like using that word gang. I shouldn't even use that, but that's a colonizer's and a law enforcement term to, again, stereotype and then criminalize us, right? And so when folks did this end of hostilities, and everybody came to an agreement to have peace, this literally scared the crap out of CDCR, right? Because now the focus is no longer on each other, and the focus is on them. And the ratio of guards to prisoners is very slim. They couldn't afford to have it 1-to-1 ratio, right? So this is why they have the divide and conquer strategy, so that we're continually focused on each other and not on a few of them. And they're just kicking back, loving it, right? Being friends with this group, hey, did you know that group said this? Or, hey, do you know this guy's a snitch? Or this guy's this or that? You know what I'm saying? Creating that state created violence. So once we're able to end it, that is the key strategy of solidarity. And then, great minds thinking alike and coming together as a unit was powerful, was one of the most powerful things that I think made this happen, made the numbers of over 20,000 prisoners statewide join this. And most of those folks weren't even in solitary, right? Those were people on the main line supporting us. And so I think that is the huge component and strategy that was necessary.
Mm-hmm.
And even, as you say that, having community support right from the outside, because it's now, it's like people rose up and together from the inside, and then you've got, you know attorneys, civil right, public interest law people, the professor Morgans of the world going like, wait a minute, right? So then all of a sudden it really starts to rattle, the cage. And I truly look forward to working towards, changing those parts of our constitution that are still, questionable, right? So we are truly changing um, the way that we operate. I do want to quote Lisa Knox, who's the legal director at the California Collaborative for Immigrant Justice. And one of the things that Lisa says is solitary confinement continues to be used as a weapon against people of color and to break up organizing efforts inside immigrant detention facilities and beyond. She goes on to say, we will continue to stand alongside those who are fighting for their basic human rights inside all carceral facilities in California. And I think, Michael, that's much of what you're saying, right? It's like solitary is something that's used as a weapon. In Professor Morgan's research, we see she calls out, hey, you know what? These color war, I mean, this is done strategically. This is not by, mistake. Michael, I know that you and I have talked about doing work around, what we call like the informant industrial complex, right? Because like the state was not satisfied drugging us, keeping us poor, imprisoning us. They then take it a step further, and now we are going to have you snitch on one another, and then we're going to stigmatize, what you're doing when you're doing what you're doing out of need, to then have you really start killing one another. So, I mean, there's just so much in this. Professor Morgan, is there something that you'd like to add? I mean, so much was just shared.
Yeah, no, it's really hard to add to what Michael captured. I shared in our kind of early, um, planning conversations that, when I was in law school, when the hunger strikes happened at Pelican Bay, and we had the fortune of having classes offered that talked about prison and prison law, and we got to study and think about the strategies, just what we could glean. I think there were like posts on blogs and what we could hear from prison radio and things like that. And so it's really a full circle moment. But yeah, Michael, I wanted to like ask you, because what you described is like a clear example of like the power of organizing and solidarity. And so I was wondering, from your vantage point, like, what did you think of law, like, and what law could do given how much y'all had achieved, right, through organizing? Like, if you were to put yourself kind of in the middle of that season, like, what was your view of law? Like, was it that it could give you all more rights and protections? Was it going to protect the organizing? Like, how did y'all fit in law to your organizing strategy?
Wow, that's a great question. An important one too, because everything was about the law. I mean, if you look at the people, the masterminds behind it, the architects, right? Most of them were already jailhouse lawyers. Most of them had already been doing litigation on this, like myself, right? And so I think that, for me, I once I began to learn the law and I began to understand its power, in a sense, certain power, right? And my first wins. So when I was initially convicted and going to trial, I had a paid attorney, right? And he just basically railroaded me, dumped on me, and so I learned. And then he said some really he tried to burn my family for money, more money, this and that, right? And I ended up finding out about the the state bar's mandatory arbitration program, right? And I went to the law library. I studied up on it, and I filed, and we ended up having a hearing, a mediator, and I won. And it was amazing because this attorney would write his briefs, and he would challenge it because you're able to go back and forth in this adversary process, right? But I was just amazed at myself that I was able to, win from an attorney, and it was weird because he's like he has to he's defending himself, right? He has to defend himself for something he did, and I got my family's money back, right? And then I began to share. I began to hear a lot of stories about other prisoners having the same issues. Even some prisoners with their lawsuits hiring attorneys to do their validations or solitary confinement issues, um, and one for them, right? And that was huge for me because man, I'm able to help somebody's family, and these families to come up, even if it was just $8,000 or $12,000, right? But for these poor families to be able to get that money and put that together, probably all their savings to get that back, is amazing. That's powerful. And then when I became started litigating in regards to my conditions of confinement and solitary confinement, and I won my first lawsuit or settlement. Because one thing that you have to understand, that people have to understand, and we do need to abolish, is there's barriers set up, right? Not just for lawyers, but for prisoners to advocate for themselves without a lawyer within this justice, within the court system, right? And that is the Prisoner Litigation Reform Act, I believe, of 1996, which sets up so many barriers and obstacles for prisoners like myself trying to navigate the law and try to overcome all these obstacles. And then there's also I forgot the exact same case, but for a due process violation, which is what we're talking about in our cases, there is no compensation, right? Unless you could prove a de minimis injury. And how do you prove that? The guards didn't beat me up. They just been keeping me in solitary without due process, but it is torture. I just can't prove physically, and in my claims and all the other claims, most prisoners get denied, and maybe you'll get $1 a nominal damages, right? Which is crazy. So having all those obstacles against you, but managing as somebody who was inside, and for my first case in regards to my conditions of confinement, I think I settled for $22,000, right? But at the time, mind you, sitting in a cell in solitary. I've already been in prison for like I think 15 years or something, and didn't have no money on my books. So that money, I was able to send money home to my parents, to my family, able to invest in law books and get all the books that I wanted, right? So for me, that was powerful. It was so powerful, even though I knew that they were continually to revalidate me every 6 years. So even if I won, I couldn't get released because they already quickly found some informants to say, yeah, he's still active. And then boom, I have to start the process again, right? But I put that actual check because they put the money on my books. I made a copy of that check and I put it on my cell wall. So every time those same bastards them same guards, right? That's what they call them, ACAB, right? All cops are bastards. So it's fitting. They would come by and see that and they'll be like, what's that? What do you got on the wall, Saavedra? So look, 22,000, yeah, what's that for, right? For you guys keep messing with me, right? It was empowerment. It was powerful. And I would tell them, keep messing with me. I'm going to keep putting more checks. By the time I get out, I'm going to be a millionaire, man. I'm going to have all my college and house paid for. Thank you. And it used to piss them off, right? But it was my way of empowering myself. And I would say, even though it wasn't, it isn't something that, because it's very hard to do. And there's very few cases that are won, right? But it does help. It does help a lot in the sense that I've helped other folks like Mr. Rubina, who was my neighbor that was blind to get reasons. They had to bring him a reader. They had to pull him out every day and give him access to these readers and stuff. And for me, that's like, hell yeah, because they're lazy ass guards. They don't want to do their job. And now they have to do it every day because we got a court order, right? And we're going to start getting them for sanctions, etc. and I'm sorry, misinterpreter Susan, if I'm talking too fast. I'll slow it down a little bit for those. Uh, but yes, I think it's a powerful tool. Um, but even more so when you learn about the access of lawyers, right? So, and quite honestly, it wouldn't have been without the help of lawyers, like folks that were coming down from California Prison Focus, who were volunteering to come in and meet with prisoners and see what was going on during the hunger strikes and checking on us, also helping us with materials. So these things are very powerful in the fact that those same lawyers were able to also be a part of the organizing of the movement of the strike, not only just the litigation, but the strike itself, right? And so there's many powerful weapons and that are within the law that lawyers can use that other folks can't, that can help with abolition, or in this case, helping prisoners to organize a movement or a litigation.
And Michael, in Discourse Law Meets World, a special issue that focused on jailhouse lawyering, you wrote a piece titled "Bound by Law, Freed by Solitary: Navigating California Prisons and Universities as a Jailhouse Lawyer." I mean, and just by the way, as I say it, I can't help but to get teary eyed because to all watching, Michael will walk the stage as a graduate, come June. So it's just so beautiful and so powerful to see that these nasty practices, dehumanizing, did not tear you down. Like, you are here in strength. You are not here at, with it. No, you are here like in power. And it's just, extremely powerful. So, in reading through the piece that you wrote, one of the things that you talked about was the catch 22, where courts require you to prove your case prior to your day in court. And you referenced the Anti-Terrorism and Effective Death Penalty Act and the Prison Litigation Reform Act, which are those strong examples of the specific barriers for prison litigants that make it extremely difficult for prisoners to litigate as effectively and as successfully as a person in the free world. How do these barriers exist? How do they affect people with disabilities?
Yeah, definitely. Thank you for that, and thank you for reminding me of that, because when you said that, you're gonna make me cry too, because whenever I talk about this, I always tear up. But I have to definitely mention, like, the hunger strikes, because I'm here and I might be wearing a nice clean shirt and a nice clean office and look happy and healthy. But the hunger strike, it wasn't just like litigation or us protesting as a group in solidarity. There were people who actually lost their lives, who sacrificed their lives for me to be here, for us to win, and to bring even more light upon what was going on. And that was my neighbor, who I dedicated that writing to, William Billy Sells, Weddle. He was a really cool inspiration. He was my rock in my community during that time. So yeah, it sorry. I would definitely say that the PRLA, the Prison Litigation Reform Act, and the Anti Death Penalty Act, if I'm saying that, the Effective Act, is very intentional in being a barrier, not even an obstacle, but like a barrier, right? To shortstop all prisoners from having their day in court, right? Like, I got to. But for some prisoners, they never get that day in court. And many of my claims never got to get into court because of the fact that the PLRA mandates that before you can even get into court, right, you have to first fully exhaust your inmate grievance, right, or 602 appeal forms, right? And so that is a whole in itself, right? Just that in itself is a very complex and has many gatekeeping barriers for you to fully exhaust it, because there's 3 levels. So for those that don't know about the prisoner grievance system, I could give you a quick little rundown so that you get a picture of it, right? So basically, if the guards beat me up, they come to my cell one night and they just hit me with their clubs or billy clubs and break my teeth, beat me up, and leave me there, and then deny me medical for a week, right? Which they had. Well, prior to I think at the time my first visit to prison, um, I believe you had 15 days. You had 15 days to file that inmate prisoner grievance form, or you would be banned, because then you didn't exhaust the process, right? So there's timing on that too, that they can deny you. The prison appeals coordinator who runs, like, accepts all that. He could be a real prick and be like, oh, guess what? You used the wrong color, red pen. Oh, rejected. Now I have to rewrite it and get another form from the guards and get it back in with those 15 days. Or you know what? You wrote two lines on one. It's supposed to be single space. Rejected, right? All these things can have your appeal or your inmate grievance rejected. And it has to go to 3 levels, right? First level, second level, third level, which is Sacramento, the director's level. And you have to have all those levels completed before you could file your litigation, or even a petition for habeas corpus on prison issues in the court system. Because if you file without that, the court's going to reject it. You're going to get a default, right? I mean, a procedural default for not fully exhausting the administrative appeal process, right? And so this is one of the biggest barriers and obstacles for prisoners who want to advocate for themselves. And the most difficult part about it is that, even say I didn't know how to navigate, I'm having problems, but I got access to a form. I call my lawyer, hey, I need help. Can you file this for me? It even says within the Title 15 of the prisoner's handbook that it has to be filed by the prisoners. It cannot be filed on behalf of the prisoner by any outside entity, lawyer, family member, etc. So then they leave the onus upon you to not only get that thing in there, but also to understand, as Professor Morgan said, the handbook, the Title 15, to understand, okay, this is what it requires. This is the type of ink you can use. This is the type of font you can use. This is where you have to send it by what day. And then you have to do the next round. And the prison mail system, as we all know, is whack. It's not, very productive, and your 602 might get lost, right? Or the guard might throw it away. So that, I think, I could go on and on about the Prison Litigation Reform Act, but another barrier is, like, say this, right? Then in, I believe sometime in 2000, after it came out, if I wanted to file a lawsuit, let's say I managed to get through all those steps of the prisoner grievance process, right? Now I'm going to file it. Guess what? It's $455 to file in the district courts, right? In the federal courts. And they'll say, okay, you don't have no money, Mr. Survey. Cool, we got you. We got you on the pay plan, right? Payment plan. So now they put a hold on your books, and anytime your mom, your sister, your kid, whoever sends you money, they're gonna take 50% off the top to that 455 is paid off, right? Then they have another 3 strikes and you're out rule within that Prisoner Litigation Reform Act that says if you file 3 frivolous lawsuits, right, or 2, I think it's 2, and then the third one you're out, right? You cannot file any more litigation. So unless it's some type of emergency, you got to go through this way out process, right? But you're pretty much struck out. The clerk will have you on the red flag list, and you will not be able to file anything in that court anymore, right? And frivolous can mean anything, because, again, going back to having to prove your case first of all, you're in solitary confinement, and you're saying that these guards did this and that all happened to you, right? And so then they're going to say, well, you have to file your claims have to be factually presented with enough evidence or what have you to be believed, which you could say, well, a declaration should be that, right? So But the opposition, the attorneys for the prison guards or the PIC is going to file a motion for summary judgment, right? And in that place, you're supposed to be able to show, your evidence or what have you. But how do you get it from? How do you even, especially in the initial? Sorry, I should go back to the beginning. When you initially file it, they have a prisoner screening process, right? So they screen, the clerks screen it, and they look for all these procedural defaults. Did they state a factual claim for relief, etc.? All these nuances that usually attorneys learn in law school how to avoid, right? Because you're taught about legal writing, what needs to be in a complaint, what type of words and evidence, etc. But if you don't have access to all that, like they're literally asking you to prove your case, right? Or it's going to be dismissed on summary judgment or what have you. But you don't have access to an investigator. You don't have access to files, to get photos, to get interviews. You're sitting in a cell by yourself, right? So in essence, it is a huge barrier. And the fact that even in civil litigation, they don't have to provide you with an attorney, right? That makes it even more difficult. So I think all those things add up to being extremely difficult. And somebody can manage that and get over all those, then I really applaud them, because that has been the most difficult thing for me personally.
And thank you for the work that you've done. And Michael, like this speaks to like your work and Professor Morgan's work on abolition, right? Because it's like, how do we move away from reform and into abolition? Even though I know that at times, that may be a problematic term, depending on who's hearing it how, or what have you. But what I'm getting at, there's very specific intricacies that when we think about reform, there's just too many layers of harm within the prison industrial complex, without including things like the gladiator fights, right? Without even including, barriers. Like something that Michael taught me was like, he said, Vanessa, here's the deal. The readers, for people who are low vision blind, those readers, they sometimes have only one reader that has to be taken from yard to yard. So by the time it gets to solitary, girlfriend, those, your 15 days are up. It's a wrap. So we've got about 10 minutes left. As we prepare to wind down, we'd like to just touch on abolition lightly, not because we're scared to, but just because it's such a robust conversation, right? That maybe we could have a whole separate discussion that we stream on abolition views. So our question is, how can legislative advocacy, such as New York's HALT Act and the California's Mandela Act, to limit and end solitary confinement, align with an abolitionist vision?
Mm-hmm. Yeah, I mean, one thing that I think is important to say is that, the state of California and the opportunity that was before Governor Newsom to sign the Mandela Act was a lot